Well, good afternoon, everybody. My name is Chen, and welcome to the Samfiru Tumarkin LLP Live Employment Law Show on Facebook and YouTube. I am an employment lawyer. I'm located in Vancouver, British Columbia. Our firm does have offices across Canada and Calgary, Ottawa, and Toronto as well. I'll be here for the next half an hour or so. Answering your questions about employment law. And so we are live. If anybody has a question about anything going on in the workplace, about severance pay, about policies in the workplace, about unpaid overtime, issues with your boss, anything that's going on at work, any issues that have arisen, please feel free to put in your questions into the text box in front of you. Hopefully everybody can see and hear me. I can't see or hear anybody, but I will be able to see your questions on my screen here. Like I said, next half an hour, please take advantage and put your questions in. Employment law since COVID has been very interesting. There's been a lot of developments, a lot of new issues that employment lawyers have to deal with. I'm always scouring kind of my Google for news. I think the big news this week, one interesting story I saw, I don't know, some of my colleagues have talked about it, but and it brings up a good point that I think I do want to talk to you guys about. This man from California was recently he was an attendant at a gas station. I think it was Shell. He unfortunately made the mistake when he was changing the prices for a gallon of fuel down there. Instead of changing it to $6.99 per gallon, I think he had missed the decimal place, and instead he charged 69 cents per gallon, which, as everybody knows, that's very cheap. A lot of people, I think, a lot of customers did take advantage at that gas station. It was a few hours before people realized, but the lines were very long. And I think that gas station ended up losing 10 or 15 or 20,000 bucks. So ultimately, when I read the story, I think his name was John John was let go. Probably, I would say because of that incident, Shell let him go for cause. And obviously, the interesting part about that story to me is, as an employment lawyer in Canada and BC, what if that had happened here in BC? What would that employee? I thought, the question is that employee still entitled to severance? And I think in that context, depending on a lot of other things like his length of service and his disciplinary history, I don't think that incident alone is sufficient to actually let someone go for a cause. And this question of just cause in the last few weeks or so has come across I've talked to quite a few people in a similar situation, not similar situation as John at Shell, but people who've been let go for cause. I think in this particular situation, if this guy had a clean disciplinary history, if he's been with the company for a while, it doesn't necessarily constitute cause just because the company lost $10,000 or $15,000, right? And the reason I say that is because it seems to me like it was an innocent mistake. And so I guess I bring this up just to let people out there know, I mean, the company could have lost a lot of money. If it was an innocent mistake, it's not necessarily cause for the company to terminate you. So I just hopefully people are aware of that. You might get a termination letter that says, dear Mr. Smith, you've cost the company $50,000, $100,000. We're terminating you for cause. That might seem like a big number to you, but it's not necessarily legally correct for the company to do that. So I thought that bring that up as an example of, if you're in Canada, of the States, the law down there is very different. If you're in Canada and something like that happens to you or something similar, come talk to an employment lawyer, come talk to me or one of my colleagues about whether the company actually has cause. The significance obviously is if you can kind of argue against the fact that they had just cause. If you're not in a union, you could get, over a year, 2 year severance paid at max. So keep that in mind. So we've got a first question here. We got a question. Recently contracted COVID. You had to take a few weeks off. Your symptoms were pretty serious. Your employer is saying you have to return to work because it's a busy time. What are my options? Okay, so that's a good question. So if you've contracted COVID, I mean, you have sick leave under the ESA, right, under the Employment Standards Act. But besides that, let's put COVID aside. But let's say you have, another medical issue, right, or something that's health related that prevents you from going to work. As long as you're able to produce some sort of doctor's note, right, some supporting documents from your doctor saying, hey, dear employer, Mr. or Mrs. Smith is unable to work right now because of medical issues, you don't have to go back, right? And I talked about this a few weeks ago, but at a minimum, you have paid sick days under the Employment Standards Act in BC, right? And your company could also have paid sick time as a policy. So I think the important thing to keep in mind is just because it's busy, just because they need you back, you're not legally obligated to go back as long as you can produce some sort of medical documentation saying that, hey, you're not able to work right now, right? Like it's not safe for you to be working right now because of your medical issues. Obviously you could go back if you're medically cleared, but just keep in mind you don't necessarily have to. We got a question here from Randolph. If your company is saying it's a for-cause termination, how do you know if they have enough reasons to actually let you go without paying severance? Yeah, Randolph, that's a really good question. I mean, so this news story that I just talked about, John from Shell in California, I mean, that one was pretty clear, right? Like he knew why he was being let go. There's certainly a lot of cases I come across where the employer doesn't actually say why they're letting you go. And I've seen letters that say, hey, dear Mr. Smith, we're letting you go for cause effective immediately. They don't actually tell you why you're being let go. So in that situation, to your question, it's kind of hard to know whether they have enough reasons because you don't know why you're being let go for cause. And one way you're able to find out is ask them, right? And if they don't respond to you, they will have to respond to a lawsuit. So you could say to your manager or HR, you say, ask them, why was I let go? What are your reasons? In terms of if they have enough reasons to let you go without paying severance. So Randall, there's probably been hundreds, if not thousands of cases where the employer says we have cause and these are our reasons, right? Like you stole money, you punched someone in the face at work, or your performance just isn't cutting it, right? You haven't been able to meet your sales targets. There's been a lot of these cases that have gone in front of judges, and judges are the ones that kind of decide, right? They decide whether these reasons are enough. And based on these cases, employment lawyers now are able to give kind of a rough they're able to make what I'll call an educated guess, or they're able to give you some guidance as to how previous cases apply to your situation, right? So for example, if you punch someone in the face at work, right, and then if there's a previous case there that an employee punched someone in the face at work and the judge found it wasn't cause, then we could use that case to say, okay, maybe that's not enough for the employer to let you go for cause. The unfortunate reality, I think, for these just cause cases, it's always so hard for a lawyer to tell anybody with 100% certainty whether it's cause or not cause. It's always more gray, right? It's okay. Well, maybe you didn't meet your targets, but maybe you had some excuse, right? Maybe you had some medical issues the previous month that prevented you from hitting targets. So it's if a company says they let you go for cause, there has been a ton of cases that have gone to trial where the employee has successfully overturned that initial, allegation of cause by the employer. So I think, and some of it's just common sense, Randolph. I mean, if you steal money from the company, that's probably going to be cause, right? But if you just don't hit your sales targets, or you say to someone, you use profanities towards a colleague one time out of frustration, that's probably not cause. It's always a matter of degree. Another big factor, and this applies, in kind of unionized and non-unionized context, but is what's your history of employment look like, right? Do you have a history of performance issues and misconduct and written warnings, like as the employer given you a final warning or a verbal warning or a written warning? That's what we call progressive discipline, right? That's a huge factor as well. Some incidents, or I'll put it this way, some things that an employee does are so bad that you can just terminate them for cause, right? Immediately. And you can say, you stole $1 million from us, goodbye, right? That's for sure cause. Some other things that an employee does, like if John at work swears at Bob and just says, hey, uses some profanities one time, that's probably gonna warrant a warning, as opposed to just immediate termination. And you have to view in the lens of how serious the conduct is. So Randolph, I know that was a long-winded answer, but I hope that answers your question. If and by the way, John, this applies to anybody. If anybody has any follow-up questions, please feel free to put it in the text box there, and I'm happy to clarify anything. We've got another question from Carrie. So Carrie asks, how much notice do you have to give your boss if you want to quit? Yeah, Carrie, that's that's a good question, and it really depends on, I mean, in my view, two things, right? Number one is your contract. If you have a written contract, well, not always, but in general, it should state in there how much notice you have to give, right? So 2 weeks. So a lot of people think you only have to give 2 weeks notice. That's, it's not legally correct, but the practical reality is a lot of employers just take that 2 weeks notice, right? They're not going to make a big fuss out of it. If your contract says 30 days and you only give 20 days notice, you're technically in breach of your employment contract, right? So technically speaking, the employer has something they could sue you for, which is a breach of contract, because you didn't give 30 days notice, you only gave 20 days notice. Now, whether they can prove they suffered some sort of harm because you gave 10 days less notice than you were supposed to is a different question. So the practical reality is most employees that give notice, 2 weeks notice, 3 weeks notice, their employer doesn't care, right? I mean, they just, they take the notice, everybody moves on. I think if I'm going to give you the legally correct answer, if there's no employment contract, there's nothing in writing, you have to give what's called reasonable notice to your company to resign, and that depends on a whole bunch of different factors, which I don't need to get into, but it's how much time does the employer reasonably need to replace you, right? And make sure there's a smooth transition. Obviously, the higher level you are, the harder it is to replace you. So, in some cases, it could be at least a few months of notice that you have to give. But I think, Carrie, for your purposes, I mean, if you're really concerned about that, talk to an employment lawyer. Come talk to me, or one of my colleagues, depending on which province you're in. And because the reality is, Carrie, 2 or 3 weeks notice in most cases, the company doesn't really care, right? I mean, they're not going to come after someone because you gave them less notice than they would have liked. But come, if your situation, if you're worried about it, come talk to me, or like I said, one of my colleagues, depending on which province you're in. So for anybody else that's just joined, please feel free to put in your questions in the text box in front of you there. I know we have people from YouTube and Facebook, and I am live here for the next 15 minutes or so. Any and all questions to do with employment law, I'm in Vancouver. I practice out of BC, so please put your questions in, and I'll do my best. I'll do my very best to answer. So another thing. So I've talked about this cause issue, which kind of one thing that's developed out of COVID. Um, and Randall, this might go to your question a bit, but there's been employers letting people go because of their failure to get vaccinated. And I remember 4, 5, 6 months ago, this was a very popular topic. The COVID vaccination policies. Employers were letting people go for cause, allegedly, for not getting the vaccine. The big story, which I'm sure most people here as maybe read, is that the federal government has lifted their vaccination policy, right? And a lot of companies are starting to call people back, and drop their vaccination policies. So I think, if anybody is in that situation or knows anybody in that situation, if you were put on leave, or if you were let go because of your failure to get vaccinated, depending on the type of workplace and the positions you were in, this news it's almost it almost supports your case in a way. That was my read of it, was, because the feds are dropping the vaccine mandate for their employees, for air, rail, transportation employees as well. I think this only supports the cases where people were let go or put on an unpaid leave because they didn't get the vaccine. Certainly, if you were on an unpaid leave before, and the employer hasn't called you back this month, now that everybody else is kind of dropping their mandates, I think that gives you a pretty strong case to claim for severance pay if that's something that you want. So if anybody, if in that situation, I would, think about that. And if you haven't talked to a lawyer, I would come talk to me or one of my colleagues about it. But that's what stood out to me when I read that news article. There's another case that just came out of Ontario, I believe. It's in a unionized context. It's against the union. It was Unifor versus, it was a division of Stellantis, which is, I think they're an automobile manufacturer. It's Chrysler. It's a corporation that formed from Chrysler. Anyways, it's an automobile manufacturer. And there was a grievance by the union, which was Unifor, against the COVID-19 vaccination policy at the manufacturing plants. And the decision came out just a day or two ago. But it was interesting because the arbitrator that decided the case, so it wasn't a judge, but it was an arbitrator. She had decided that the finding was that while the COVID-19 vaccination policy, right, mandatory vaccinations for these plant workers were reasonable back in December, January this year, February this year on to now, it's no longer reasonable. And I think the finding was that there was a negligible difference between for the risk of transmission of the virus between unvaccinated people and people who had 2 doses of the vaccine. So I thought that was very interesting. It just kind of shows that, as of right now, there's a recognition that perhaps vaccination policies that were reasonable before are not so much anymore. At least one case that's how it went in the unionized context. So I think that just goes to my point that, especially for the people, if you're still on unpaid leave, or if your employer suspended you because you haven't got the vaccine and they don't call you back right now, I think just as a heads up, it's these cases, the news that's coming out is only supporting a stronger case for claiming severance pay, in my view. So we've got some more questions here from Greg. So Greg is asking, can you be put on an unpaid suspension after an incident with a colleague? You've reported bullying and harassment, but your complaints have gone unheard. I'm the one facing a suspension. Yeah, Greg, I'm sorry to hear that. So let me try to give you some general guidance on that situation. And I'm going to be talking about the non-unionized context, I think. If you're in a union, it's a bit different. But let me talk about it. In the vast majority of employees in Canada are non-unionized. So let me talk about that context. If so, typically an unpaid suspension, unless it's in your contract or some sort of policy you've agreed to, they can't put you on an unpaid suspension. Okay, they can give you warning letters, verbal warning letters, final warning letters, but an unpaid suspension generally is seen as a constructive dismissal, right? And which means the employer doesn't have a right to put you on that. The fact that you're the one that reported the bullying and harassment, but now you're the one that's facing suspension, makes your case even stronger to claim for severance if that's what you want, right? It's also in BC what we may call a prohibited action, right? Is you made this complaint of bullying harassment and now you're facing disciplinary measures. So I think you have legal avenues that you could go down. It obviously depends on what evidence comes out, right? So the fact that you're on suspension makes me think that maybe the company made a finding that you were the one that was the the bullier, or the one that harassed the other person, right? I don't know, but it really depends on the evidence that comes out and if you can substantiate the bullying and harassment by this colleague of yours. But in general, no. I would say that if you're put on an unpaid suspension, it gives rise to a claim for constructive dismissal. And there's been at least there's been, I believe, a case from the Supreme Court of Canada on that issue. So Greg, my only advice to you, because it's such a nuanced these nuanced situation with bullying and harassment, there's always details that really do matter. The devil's in the details. My only advice to you right now is talk to an employment lawyer. Come talk to me, or one of my colleagues, if you're depending on the province, but go to employmentlawyer.ca. We do have a lot of articles on bullying and harassment specifically. So it's going to take more than our chat here, Greg, to kind of figure that out, unfortunately. And that's only because there's a lot going on, I see, with your situation. So why don't, Greg, if you have any follow-ups, please feel free to put it in the text box there. We've got another question here from Martin Knights. Your employers told you your business doesn't have to adhere to the Employment Act. They said it doesn't apply to our industry. Is this true? Are there certain industries who can opt out? Yeah, Martin, that's it's true to some extent. And I'm going to talk about BC, Martin, just because I'm most familiar with law in BC. I know other provinces, their respective Employment Standards Act are very different, right? Because employment is generally provincially regulated. In general, there are obviously federal regulations. So in BC, certain professions, there's actually a list. Last I looked, it was quite a long list of professions or occupations that are explicitly exempt from the Employment Standards Act. So just to back up, I mean, Martin, I assume you know the Employment Standards Act, it's supposed to protect employees, right? So the general assumption is that it applies to everybody in BC, right? Unless you're federally regulated or you fall under an exemption. I, as a lawyer, am excluded from the Employment Standards Act, right? So I don't get that. I don't get that protection. Accountants are excluded. Licensed engineers are excluded. Interestingly enough, construction employees are not excluded from the entire act. They're excluded from certain sections of the act. So there are industries, they're not opting out, they're excluded by legislation, which means that the government, when they wrote the statute, they carved out certain jobs and occupations or professions that the act does not apply to. So I mean, Martin, if you have a specific industry that you want to let me know what it is, I can maybe try to figure out if it is excluded. But yes, there are certain industries that are exempted. It's not an option to opt out. They're exempted from the act, unfortunately. Why? I don't know. There's certain jobs that are exempted from the act just don't make sense to me. But the law is what it is. So we've got another question here from Bill. What if your dismissal was a reprisal, but it is not covered under occupational health and safety or human rights violation? Yeah, Bill, I think you're going to have to give me a more specific example. I can't think of anything that wouldn't be, I mean, if your dismissal was a reprisal, I mean, I guess OHS would cover bullying and harassment, right? Human rights would only have to be connected to one of the enumerated grounds, so race, disability, sexual orientation, and that stuff. So, I mean, what was the reprisal for? Because I can see a reprisal not being connected to any of those things covered in those two acts. At the end of the day, I think that it may give rise to more damages. By damages, I mean monetary compensation for wrongful dismissal, right? If the employer, if you did something that is, right, and the employer terminates you for it, if it's not covered under those two acts, I can see maybe a finding of bad faith against the employer. Again, it's hard for me to speculate, but if you give me a more specific example, maybe I can shed some light. Okay, so we've got another question. So we've got a question from Great to Sarah's, and then I'll do Martin's first because I know you had a follow up. You're in the shipping industry, but you're in an administrative position here. Yeah, Martin, I think you might be covered under the Canada Labor Code if you're in the shipping industry. Anything with international, interprovincial transportation, you're not going to be covered by provincial legislation. You're probably going to be covered by federal, which means that it's probably the Canada Labor Code that you're subject to. So maybe that's why they said you were excluded from employment from an employment act. So Great Tesaros asks, if I submit a human rights complaint for discrimination in good faith, is that considered a reprisal? Yeah, I mean, yes. Yeah, if the reason they let you go was you putting in a human rights complaint, and then you obviously, and you have the evidence to back that up, that's why they let you go. And most of the times that's timing, right? Is you file a complaint, a week later you're let go, then yes, that's considered reprisal. Can this reprisal be submitted as human security rights separated from the first? So basically, I'm pretty sure you do. You're gonna have to, don't hold me to this answer. I don't know if you submit it on top of the first one or if it's a separate second one you submit. But it is definitely a complaint you should submit. And I'm just, come talk to me afterwards if you're in BC, obviously. And my contact should be somewhere on the screen or somewhere, or just go to our website. My contact will be on there. I don't want you to quote me on it. I can't remember if it's part of the first or you submit a second fresh one, but it is a complaint you can make, absolutely. Okay, guys, so I think those are all the questions that I see on my screen. If anybody has any last minute ones, please put them in here. I will be back in 2 weeks. My colleague Darren's on next week. I do have, there are some lawyers from our firm in Ontario that do these as well. But I think I'm gonna call it there. But I'll see everybody in 2 weeks. And for the people who I couldn't get to, or people who need to follow up, please feel free to contact me. I'm happy to chat about your situation. Certain situations do take a consult, unfortunately, and I can't do it on here. But please feel free to contact me. But yeah, I hope everybody has a good weekend, and I'll see everybody in 2 weeks.